I'm Ken Davis. I'm Dean of the Law School, and it's my privilege to welcome you to this year's installment of the lecture series created by the clerks of the late Judge Thomas Fairchild of the Seventh Circuit to celebrate his illustrious career. It's always one of the both intellectual and social high points of our academic year here, so I'm glad you could join us, notwithstanding the weather conditions. Our Fairchild Lecture this year is Patrick J. Fitzgerald. For the last 7 years, he served as U.S. Attorney for the Northern District of Illinois, and has also been involved in or led some of the most noteworthy criminal investigations and prosecutions of recent times. Most recently, he served as special counsel to investigate the Valerie Plame leak, and then served as lead counsel in U.S. versus Libby. Prior to his joining us here in the Midwest, he served as Assistant U.S. Attorney in the Southern District of New York, where again he was involved in a number of the significant cases of that era, including he headed up the Organized Crime Terrors Unit in the Southern District Office, and also participated in a number of high visibility prosecutions, including those arising out of the bombings of our embassies in Kenya and Tanzania and the World Trade Center bombings. He's a native of Brooklyn and is a Phi Beta Kappa graduate of Amherst College and also a graduate of the Harvard Law School. So please join me in welcoming to our law school Patrick Fitzgerald.
Thank you, Dean. I have to say that when I was invited to speak last fall, I was quite flattered. And then when I looked into the Fairchild Lecture series and saw both that you had published your remarks when you were done, and then saw who had preceded me as a Fairchild lecturer, ranging from Judge Lefkoe, one of my heroes in the Northern District of Illinois bench, to Supreme Court Justices Stevens and O'Connor, I was a bit daunted to speak and lecture in an academic setting. So I thought maybe I could just weasel out of this. But the reason I'm here is the person who asked me, Judge Radji, is someone I met way back in 1978, the year after she clerked for Judge Fairchild, and she was not then a Second Circuit judge, but instead an associate, at a young associate at a firm in New York, where I was a high school kid interning in a library. She spent a lot of time giving me advice on what to do in college, and I never forgot that. So I knew I was stuck saying yes. But I got over it with two things. One, the help of Kate Christie, a third-year student at Loyola Law School, looked up some law for me, which was good. And secondly, when I saw the law, I was gratified to see a quote that said, when you talk about jury service, it is a topic that has suffered from, quote, astonishing scholarly neglect, close quote. So I figured I can wade in there. So what I'd like to do is have some thoughts about jury service and how the legal system treats jurors, both with reference to law as in L-A-W and lore, L-O-R-E, in terms of personal experiences. And I thought I'd start you out with a brief story of a case that I remember but no one else does. And it's a case I prosecuted called United States versus Reyes, which involved a drug deal on the Upper West Side of Manhattan, where a guy showed up with $160,000 in cash in a paper bag to give to an informant thinking he was buying drugs, when instead he was to be recorded in a drug deal. And I got the case, I tried it with a couple of days preparation, taking the case over from another assistant who was booked at 2 trials. And we went through the trial, and the little problem we had was that the informant's tape recorder didn't work, so it was a bit of a circumstantial case, and we had a fun trial. And at the end of the trial, the jurors retired to deliberate. And one problem we had is that the defense made a motion at a certain point to declare a mistrial because he said you could audibly hear the jurors arguing in there. And I rose to oppose this motion in front of Judge Kimball Wood in the Southern District of New York, and I knew I was losing when I had to raise my voice over the din of the jurors arguing in the room behind the courtroom. A mistrial was declared. The judge then told me that the jurors wanted to speak to me. So I went to the back room, and there were 11 jurors very anxious to have me yell at the holdout juror who had indicated that she would not vote to convict the defendant because of the defendant's race. And it was a very uncomfortable moment, and all I wanted to do was get out of there, although someone else wanted to get out of there a little quicker. and I just promised the jury that we would retry it. So we went back to a retrial. The case changed significantly. I won't bore you with the details. It got a heck of a lot better for me because one of the alibi sort of witnesses who took the stand with the Bible in his hand at the first trial turned out to be less holier than thou than you might think, since he had been a fugitive of an inside armored car heist with the defendant prior to testifying, and I thought that would aid my presentation to the jury. Next time around, it got a lot worse for me when I found out my informant with the blank tape had perjured himself at 8 prior trials about his tax situation and fabricated documents that had indicted him shortly before I put him on the stand. So it got better, it got worse, but I went in there with this goal. I had a jury 11-1 to convict, and I had to bring them to unanimity. And I did, which is about the best spin you can put on an acquittal. And what was frustrating was when the jurors came out, the fellow we tried had a history. He had been indicted in the Southern District of New York in a counterfeit case, came up with a defense of Dick Tracy syndrome, hysterical personality disorder, for which he received a mistrial, a hung jury back in the 70s. He decided to drop the case. He got indicted again some other time and beat the case, and I think he had his case dropped in Brooklyn, where he'd been involved in a car heist. I then had participated in a trial which resulted in a hung jury, and then an acquittal, which was a little bit frustrating. So the jurors came out, and what they said to me as I waited at the elevator was, "Oh, good job, you'll get him next time." I might have forgotten that slight until a year later when a Bronx DA called me to let me know that he was putting on a victim of a robbery, a man who had a substantial amount of cash taken from his bodega, and that he seemed like an excellent witness and gave me as a reference. And I quickly realized it was the defendant that had taken the stand, who I had cross-examined, was now using me on his resume as a reference as a witness. I took a lot of lessons from that case. One was humility. But the other lesson I took away is you do have issues where jurors do things for what appear to be inappropriate reasons, like race, and that can be frustrating. But I also took a more positive note, which is that the second jury obviously believed this person was probably guilty. They said, "You'll get him next time." And yet they felt the evidence didn't measure up. So they did not return a verdict of guilty. They returned a verdict of not guilty, which is an important lesson to take away. With that, my essential thesis today is that in the history of juries, we've had a lot of issues sorted out, but not all of them. We have sometimes treated juries in history very poorly. We're getting a lot better. There's a lot more of an effort to involve juries in the process these days, but there's room for improvement in how we treat jurors. But again, my conclusion is the most important thing is how judges treat jurors and how the public respects them afterward. So let me briefly digress into a little bit of the history of juries. The commentators have basically agreed largely that the modern jury began to emerge around the 12th century in England. And that's following the Norman Conquest, when William the Conqueror showed up in England and decided he needed to assemble a doomsday book, so he knew all the property, all the land, all the cattle that belonged to him. And so they went around using jurors, people who were part of the community, to gather this information. So they picked jurors who actually knew the facts. It helped that the alternative for people to a jury trial was trial by ordeal, which wasn't a very pleasant process. If you had rocks tied to you, and they'd try to figure out whether you could swim. And later in the early 13th century, Pope Innocent III, at 1215, actually prohibited Catholics from participating in trial by ordeal. So jury service took off in different forms. 3 cases I'll talk about from the times prior to the colonies show you how the jury system evolved. One was the case involving Sir Nicholas Throckmorton, and he was tried for treason, and it was in 1554. And the interesting part about the case is a lot of the interesting jury cases involve seditious libel and treason in England. There was apparently overwhelming evidence, and the jury acquitted. And what's interesting is that the result did not sit well with the judge. He punished them in a Star Chamber proceeding, and they were imprisoned for the rest of the year, and they're given the option of being in the Tower or going to the Fleet and serve their time, and after release had to pay a fine. The acquitted man was also sent to jail. So the respect for the jury process wasn't very high when the acquitted went to jail and the jurors followed him. A little later, about a century later, a case in 1649 involved Sir John Lilburne. And this has been cited as the first time a person, a defendant, made an appeal for jury nullification. He too was tried on a basis of treason. He was denied the right to counsel, so he had to argue for himself. And he argued to the jury that the jury should determine the law. The judge thought that argument had no merit. The judge mocked Wilburn's performance at trial, and then the jury acquitted. And after he was acquitted, he was banished. But being banished, he still came back and was tried again a couple of years later, this time on a capital offense. This time again, he argued to the jury. And he argued to the jury an interesting form of jury nullification, the punishment. He said to the jury that they should acquit him if they thought the death penalty was, quote, unconscionably severe, close quote, for the acts he committed. And the jury's verdict was that they found him, quote, not guilty of any crime worthy of death, close quote. And that word went out in England that jurors essentially had the power and were in the practice of acquitting when they thought the charges were unpopular. The most important case and the most famous case was the case of William Penn, the guy who would later come over to the United States and hence Pennsylvania. But in 1670, he was tried also of some form of seditious libel. And the jury decided to find him, quote, guilty of speaking in Grace Street Church, close quote, but wouldn't find him guilty of the charge. The judge was not happy, and imagine what the judge told the jury. He told them that they would, quote, shall not be dismissed until we have a verdict that the court will accept, close quote. And in case they didn't get the message, he added that, quote, you shall be locked up without meat, drink, fire, and tobacco. You shall not think thus to abuse the court. We will have a verdict by the help of God, or you shall starve for it, close quote. The jury went back, and not liking the case that the Crown had brought against William Penn, they refused to convict and decided to acquit. After that, the judge was still very angry and ordered them to pay a fine, and one juror named Edward Bushell was confined because he refused to pay the fine and brought a civil suit in the Court of Chancery, where the judge in England held that it was improper to fine the juror. That was known as Bushell's case and stood for the proposition, finally, that a judge could not change a jury's verdict no matter how much the judge disagreed. The same principles were going on in the early colonial times. In fact, England had trouble convicting in the colonies for people who were smuggling. They had trouble winning before jury trials when they tried to collect money. In both England and the colonies, English laws were passed to try to remove cases from courts that had juries. Perhaps the most famous case that resonated in the colonies was the case of John Peter Zenger in 1734. And it was in New York. And the governor back then was William Cosby, and he was not very popular. The Chief Justice in New York was a fellow by the name of Lewis Morris. Well, the governor was greedy, and he wanted to take part of a salary of someone else who he thought had received part of the governor's salary, so he sued. He didn't think he wanted to be in front of a jury, so he had a motion that the case should be brought in a court without a jury. And the Chief Justice Morris dissented in his decision and basically explained that he didn't think that the case should happen in a trial without a jury. Following that, the governor fired the Chief Justice. The Chief Justice was not happy, and some of the supporters of the Chief Justice and the opponents of the governor founded a newspaper of which the printer, John Peter Zenger, became the publisher. He published an article criticizing the governor, including complaining about the fact that the governor was taking away the right to trial by jury. He was then, they then sought to have him indicted for seditious libel. 3 grand juries refused to indict. So the governor had an information filed against John Peter Zenger. When he went to court, his lawyers sought to disqualify the judge as being too tethered to the governor. They lost that motion, and the judge later disbarred the defense counsel and appointed a lawyer who was friendly with or loyal to the position of the governor to represent the person charged with seditious libel for opposing him. After the opening argument, a fellow named Andrew Hamilton, one of the most famous lawyers in the colonies, stood up and agreed to represent the defendant. He also announced that the defendant wouldn't dispute that he had published the materials, but that he would argue to the jury he should be acquitted. At the time, the system that was proposed and was in place was that if a seditious libel was charged, the jury would just render a verdict as to whether the person had been responsible for printing it, and the judge would decide whether it was libelous. And truth was not a defense. Mr. Hamilton stood up and argued that the jury should return a general verdict and just say guilty or not. The judge agreed, although instructed the jury that truth was not a defense, and to the judge's surprise, the jury acquitted. And that was a seminal moment in history where it became clear that jurors would acquit and it also established that truth was a defense in libel. As time went on, this issue resonated in the colonies, and in fact, the Declaration of Independence had language reciting the fact that people had been deprived of their right to a trial by jury. In the time between 1776 and 1787, every state constitution that was adopted included the right to trial by jury, which was the only right included in all the constitutions. In the Constitution itself, in Article 3, Section 2, the right to trial by jury was guaranteed, but then again in the Bill of Rights, the trial by jury appeared 3 times. The Fifth Amendment required indictment by grand jury, the Sixth Amendment provided for trial by jury in criminal cases, and the Seventh Amendment provided for trial by jury in civil cases where certain amounts were involved. It was the only right included in both the Constitution and the Bill of Rights, and the right most often mentioned. I say that to just emphasize how important it has been that our tradition is that we respect the role that juries play in the system. I'll briefly note it as an aside that we should not be confused that as much as we glorified the right to trial by jury, it was not a very democratic jury at the time of the colonies. It was white male landowners in most states who were allowed to vote. Remarkably, the Supreme Court held first in 1880 that it was unconstitutional to exclude blacks from the jury, but it took until 1975 for the Supreme Court to hold that it was unconstitutional to exclude women from the jury. As late as 1961, there was a case where women were excluded from the jury rolls unless they volunteered to serve, and when a defendant challenged that practice, the Supreme Court held it was constitutional. And what was odd is that in that case, it was a woman charged with murdering her cheating husband who wanted to have women more represented in the jury. And later in 1975, it was a man charged with rape who had his conviction overturned because women were not represented in the jury pool. But the more important focus for today is to focus on what powers the jury had. And I'd like to note that in one case that became important called Spark, the Supreme Court decided that jurors had the right to decide the facts, but the judges could decide the law. And what I'd like to focus mostly on is the instance of jury nullification. It became important that people could see whether or not jurors could decide to take unpopular laws and vote against them. And the issue of whether a jury could be told what to do arose in a number of cases, but the one that sticks out the most is a case called Horning versus the District of Columbia that was as recent as 1919. And in 1919, a judge in D.C. was faced with the prospect of a person charged with being an illegal pawnbroker. He was making loans in the District of Columbia. A statute was passed that said you cannot loan money at greater than a 6% rate of interest. This man set up an office across the bridge in Virginia and had a car that would ferry people over where they would sign the contract, cab waiting there, and evidently he thought that this was a sophisticated way of complying with the law. When he went to trial, the government called witnesses showing that he was making loans by driving people from Washington to Virginia and back, and he put on witnesses that showed the same thing. So the judge basically told the jury in these words, which I think are remarkable. This is the instruction the judge gave the jury how to decide guilt or innocence. The first part sounds pretty traditional. It says that the law makes the jury the sole judges of the credibility of witnesses and the weight of the evidence, and goes on to say, no court or other person is permitted to intrude into your province and control your judgment in the matter. But then the judge added, but we have not a case of that kind here. In the case of the at bar, there is no conflict in the evidence upon any material point. He then goes on to say, therefore, there is really no issue of fact for you to decide. You are not authorized to capriciously, arbitrarily say that the witnesses for the government and the defendant are not telling the truth, that the course of dealing of the defendant is other than as described. The Court of Appeals has decided that such course of dealing is a violation of the law. That decision is binding upon me and upon you alike. It is my duty to be controlled by it. It is your duty under your oaths as jurors to accept as correct and be governed by the exposition of the law which I gave you. In a criminal case, the court cannot peremptorily instruct a jury to find the defendant guilty. If the law permitted, I would do so in this case. The defense attorney objected, and it went on a bit. The defense attorney objected, so the judge clarified, and the clarification was as follows. Of course, gentlemen of the jury, and it was an all-male jury, I cannot tell you in so many words to find defendant guilty, but what I say amounts to that. The facts proved before you are in accord with the information. The Court of Appeals has said that that constitutes a violation of the law, and that is all there is in the case. That went up on appeal. On appeal, it was affirmed by the District of Columbia Court of Appeals, and then it went on to the Supreme Court. And as great a justice as Oliver Wendell Holmes wrote for the majority, which affirmed that conviction. And Justice Holmes said, in such a case, obviously the function of the jury, if they do their duty, is little more than formal. If defendant suffered any wrong, it was purely formal. Perhaps there was a regrettable peremptoriness of tone. If the defendant suffered any wrong, it was purely formal, since if we said the admitted facts, there was no doubt of guilt. I will not read the rest of the discussion, but I would note that Justice Brandeis dissented and noted, quote, whether a defendant is found guilty by jury or is declared to be so by a judge is not under the federal Constitution a mere formality. What's interesting to note is that may sound like a complete anachronism, but as recently as 1995, the Supreme Court characterized horning as an unfortunate anomaly and noted that it was repudiated. But after Galvin, in 1998, the Fourth Circuit affirmed a conviction where a judge told the jury, quote, I believe defendant was acting illegally as a drug dealer, close quote, on the facts of the case. And it was a split decision with the majority noting the horning case had not been overruled, though criticized, and the dissent by Judge Luded, who said that he thought the Supreme Court would repudiate Galvin if before. So as recently as 1998, we've had a judge affirmed telling a jury that his belief was that the defendant was guilty. The law appears pretty clear these days that jurors can nullify. They have that power, but they're told they're not advised that they have the right to do so. And that's pretty well settled in most of the circuits. And in fact, one circuit that would be an interesting example to talk about was the case of Dellinger in 1972, an opinion written by Judge Fairchild. And among other issues, Judge Fairchild noted that a jury is not entitled to an instruction on jury nullification, noting that the jury has the power to ignore the law, but not the duty to do so. And if we wanted to get an insight into Judge Fairchild and sort of a time capsule of how he looked at jurors, if you looked at that opinion, you would note that in reversing the convictions of the Chicago Seven, Dellinger was one of the defendants, but Abby Hoffman and others were far more famous than Tom Hayden. The judge noted the failure of the trial judge to take steps to correct for any prejudice in the jury pool. Now, there should have been more questioning of the jurors in 1969 about what their attitudes were toward the Vietnam War, what they were toward law enforcement, what they were toward the hippie movement, that more questions should have been asked about pretrial publicity, and that it was improper for the judge during jury deliberations to accept notes from the jury and respond to them without telling defense counsel so there could be input as to whether or not the jurors should receive transcripts. And the judge also made it clear that he criticized some of the conduct during trial when the trial judge made comments disparaging defense counsel in a way that he thought prejudiced the jury. And frankly, my predecessor as United States Attorney was criticized for also making improper comments. So clearly, under Judge Fairchild's view, judges should not make comments or take actions that prejudice a jury. Having said that, I'd like to move forward in time to a more recent issue, which has to do with anonymous juries. And if you look at the case law and the famous cases that talk about the power of juries in the medieval times up until the colonial times, you saw lots of cases about treason and seditious libel. When it came to the time that people started making jurors anonymous for their protection, those cases started as narcotics and organized crime cases that brought that about, and more recently moved into the terrorism context. An interesting note about anonymous juries is that the first one impaneled was in the case of Nicky Barnes in 1977. Nicky Barnes was a very famous drug dealer in Harlem, in Manhattan, and when he went to trial, before he went to trial, he made at least one tactical mistake. The New York Times did a profile of Nicky Barnes and called him Mr. Untouchable, and then they called him and told him that if he didn't pose for a picture for the cover of their magazine, they would use a mugshot. So he then posed for the cover of the New York Times and was out there on the front page of the New York Times Sunday magazine as Mr. Untouchable. He was indicted the following year. When he went to trial, an application was made to make the jury anonymous. And that was the first time recorded that a jury was made anonymous. The court noted the prior history of jury tampering, in interference with jurors in the Southern District of New York and granted that motion. You can wonder how effective the unanimous jury can be because after the trial, Mr. Barnes was convicted, and after he was convicted, he decided to cooperate with the government, and then he became a witness in a subsequent case called U.S. v. Thomas against some of his Confederates. And the government sought and obtained an anonymous jury in Thomas because they had an affidavit from Barnes explaining how his co-defendant had bribed one of the anonymous jurors in their earlier trial. But the one thing I really want to talk about with regard to the anonymous juries is what it is that we reflect about how we think about jurors when we explain to them why they're suddenly brought into court and listening to a case with their identity concealed. And the one thing I think that we've done that I question is we often tell jurors reasons for the anonymity of the jury that aren't quite accurate. And maybe the best example I can give is a district court case from the District of Columbia named Edmonds. And the instruction the jury was given is as follows. It is a common practice, followed in many cases in the federal court, to keep the names and identities of jurors in confidence. This is in no way unusual. It is a procedure being followed in this case to protect your privacy, even from the court. Close quote. So if you were a juror sitting there, you'd be thinking, oh, this happens all the time, and we're doing this to keep the court away from me. If you read the opinion justifying that instruction, you would note that earlier in the opinion, it would make plain that this was the second of a series of 3 trials, that the first part of the trial in that case had been the first time in the history of the District of Columbia they ever had an anonymous jury. That during that trial, there had been a potential witness had been murdered. The house of the mother of the witness had been firebombed during the witness's testimony. The defendant had made a machine gun gesture toward the judge, and efforts were made at identifying the jury. And you wonder when jurors start hearing about evidence of violence, whether or not they will credit the judge's explanation early on that this is an ordinary practice and that you're being shielded either from the media or from the efforts of the court to invade your privacy. And I would note that in a different approach, the Third Circuit, in a case called Scarfo, involving a boss of the Philadelphia family, the trial judge there gave a much more candid description to the jury in a way designed not to prejudice the jurors. And his reason for that, he said, is that, quote, judges must deal honestly with juries or the entire system will break down. He basically told them that it was a strong personal belief that no juror was in risk of being harmed, that in all the years in the bench, no one had ever harmed a juror, but implied that he didn't want anyone to be contacted by someone and have any fear, and worried that somebody unconnected to either party might make a contact with them that might put them in apprehension. And the Third Circuit approved that instruction, approving of the candor of telling the jurors why they were anonymous. And if there's one area I think that I will talk about later, is that judges, I think, can enhance the performance of jurors by showing them respect and making them an integral part of the process. And I think when we deal with anonymous juries, we should find a neutral way that is more credible to tell the juries why that's going on. Let me tell you about 3 anonymous juries I dealt with personally and some lessons I took away from that. The first was a case called John Gambino in New York, where Judge Leisure impaneled an anonymous jury in a case that involved allegations of decades of heroin trafficking, cocaine trafficking, as well as bribery, leading an escape from jail, assassination of a public prosecutor in Italy, and bribing a juror in Brooklyn. So it was well justified why there was an anonymous jury. But I learned a lesson when the judge had the jurors fill out a questionnaire. And the questionnaire was designed, as it is in most of the other cases where the juries are anonymous, to elicit more information. And one of the questions at the end of the questionnaire, and I will tell you, lawyers are control freaks, so the questionnaire was new to me, so I instantly opposed it. I later became a big fan. But one question at the end of the questionnaire asked the jurors, this will be a 6 to 9 month trial involving allegations of organized crime, etc. Would you like to serve? Yes or no? And please explain why. And I remember, and I believe it's this anonymous jury that the answers came out, 2 answers that were there that gave me an awful lot of insight about the jurors that they would not otherwise have had. One juror wrote, I would like to serve. I am a truck driver. It is winter. It is cold outside. And I would like to spend the next 6 months in a warm courthouse. Now, that was an honest answer that gave both sides a very clear insight into what this juror was about. The second answer was from a different juror who was more elderly. And he wrote a note that said, for years I ran my own business. And every time I was called to jury duty, I would ask to be excused by the judge because they didn't think my business could afford my absence. And I told all those judges that someday, when it's otherwise, I will serve. And I was excused from jury time after time. And now I am retired, and I feel it's my duty to step up and serve on this jury. And you looked at that answer, and you saw a completely different reason. What a remarkable insight into the jurors. Another anonymous jury was impaneled by Judge McCasey, now the Attorney General, in the case of U.S. versus Albert Rockman, which involved the World Trade Center bombing, a plot to blow up the bridges and tunnels, a plan to assassinate Hosni Mubarak, and also the assassination of Meyer Kahane by El Sayed Nosair in New York, which actually had been tried before in state court and was described as the most irrational verdict the state judge had ever seen. A man had walked up into a room in Midtown Manhattan, pulled out a .357 Magnum, shot Meyer Kahane dead in front of the crowd, ran to the back of the room, encountered a 76-year-old man named Irving Franklin, who struggled with him. He shot Irving Franklin in the thigh, ran outside, was chased by a crowd, accidentally ran into a postal police officer closing up the post office, engaged in a shootout. The postal police officer shot Mr. Nosair, who fell to the ground with the weapon to his side that had shot the police officer, Mr. Franklin, and had killed Kahane. The jury acquitted Mr. Nosair of the murder of Kahane and the other two shootings, but found him guilty of assault and possessing the weapon that carried out all three shootings. And I note that because I'm a big fan of jurors, but you do have to note that sometimes the verdicts are not the most rational. Judge McCasey faced a questionnaire for the first time in that trial, and in a recent interview that became published by the Federal Judicial Center, he indicated that he was against the idea of a questionnaire and afterward became a big fan of it. 500 questionnaires were given out. The judge decided to instruct the jury on the law before opening statements so the jury would know what seditious conspiracy was, or at least have an outline of it before they heard the case. And he kept the jury anonymous, but did not sequester them for such a long time. It was a 9-month trial, and he had them driven to a remote location, undisclosed, and the marshals would pick them up and bring them to the courthouse and return them. Two things about that jury that stuck in my mind was that at the end of the trial, there was a single count on which the defendants were acquitted. And I remember that when the jury instructions were gone over and over and over by defense counsel, government counsel, and the judge, we were happy with where they were in the end. When they were read out loud, they sounded sort of funny in explaining one particular charge, for which the evidence was ample. But hearing it out loud, we all agreed it made it sound different. And that was the jury, what the jury acquitted on, which showed me that in a case involving terrorism and 9 months of trial and some huge number of counts, they paid close attention to the judge's instructions. The second thing that happened during that trial is something that happened on April 19th, 1995. The 13th anniversary will be tomorrow, will be the bombing of the Oklahoma City Federal Building back in 1995. That happened during the trial while we were putting on proof about the World Trade Center bombing. And Judge McCasey wisely rejected a motion to sequester the jury and made it clear that he should just tell the jury to try to avoid the press, but make it clear that that had nothing to do with the case before us. It was a very wise move because I think the best way to communicate to a jury that something outside the courtroom is unrelated is to act as if it was. And had he sequestered the jury in response to a bombing, they would have no doubt heard about it. He would have reinforced that there was a link. And the final jury I'll talk about, the anonymous jury, was the embassy bombing case before Judge Sand in the Southern District of New York. And that's the same Judge Sand who has a treatise on jury instructions. And Judge Sand in that case had to deal with a trial that would go 7 months long, would involve Al-Qaeda and Osama bin Laden, bombings of 2 embassies with over 200 people killed, and 2 defendants facing the death penalty and a massive publicity. Judge Sand gave out 1,500 questionnaires. Out of that, there were 30 pages in length, and 1,302 potential jurors were sat, and 2/3 were excused for hardship. He then voir dired the jury, and I think in a very wise move, sealed the jury, sealed the voir dire until a later point in time, saying, quote, that if we want panelists to be candid, it would simply be unfair to them and steer the process for them to know that the following day there may be a newspaper account. And one example that will tell you that you can't think you know a lot about jurors is to see how he vetted people for the death penalty. The questionnaire asked if people had strong feelings about whether or not the death penalty should be imposed, if they had strong feelings whether they considered the case on the merits despite those feelings, and asked them to narrate any explanation of their views. In that jury selection process, there was one juror who identified himself as believing in reincarnation, who indicated that he did not oppose the death penalty, and said, quote, "The death penalty is just changing the mineral in water from an improperly behavioral person to another creature, possibly or improperly behaved." Close quote. When we saw that answer, I thought, now there, if ever, is a defense strike. The defense didn't strike in the early strikes, and I thought they were saving this one for last, figuring that's the one they had to strike, and they didn't want to give us any intelligence. The defense left this person on the jury, and I read in a newspaper account later that the defense attorney thought that this juror was a wild card, and that this would be a good thing to leave on the juror. After the jurors deliberated, they deadlocked on the death penalty. It was not imposed. And an enterprising reporter for the New York Times found a way to make contact with an anonymous juror, who put him in touch with the other anonymous jurors, who agreed to talk to him on the condition that he not use their names or learn their names. So they set up locations for them to meet. And during the interviews that he later published an article, it was that juror who led the charge for holding out against the death penalty. So it shows you that the defense attorney who had a hunch that this wild card might work knew what he was talking about. The other issue that I think is, besides dealing with anonymous juries and giving them an honest account, or the best honest account you can give them of why they're anonymous without prejudicing the defendant, is the issue of questioning, allowing jurors to issue questions. And again, I think lawyers by their nature are control freaks, and judges sit in the courtroom trying to be in control of the control freaks. And the notion that somebody in that jury box might actually throw questions out and upset the order of what we do is something that's anathema to both lawyers and judges. And the instinctive reaction for everyone is to say, no, don't do it. Well, there was a project in Arizona where they filmed 50 civil jury trials. And remarkably, they filmed the deliberations as well, with waivers. And they did an analysis to see whether or not the preconceptions that this would take a lot of time would result in argumentative questions, and all sorts of other things would happen. And the short version was that they found out at the end of the day that jurors did not become wedded to their questions, that the number of improper questions was fairly low, the number of argumentative questions was less, and that the jurors felt that they got a lot out of it, and most of the participants became bigger fans of jury questions. Later, the ABA in 2005 issued a policy statement favoring the possibility of jurors asking questions. And the Seventh Circuit, then Chief Judge Flom, encouraged a pilot project in which judges participated, district judges from the 3 states in the Seventh Circuit. And he wrote an article later where he said that he had been skeptical of the whole process of jurors asking questions, as had been many of his colleagues. But at the end of the day, he too became convinced that they were very worthwhile. One finding from the pilot project in Arizona was that letting jurors ask questions added about 1.5 minutes per hour to the trial, and no more. And I will tell you that having read Judge Holderman say that he had been reluctant, and all the other judges say that they had been reluctant and became convinced. Having read the Arizona project that said that they were reluctant and became convinced. When Judge Reggie Walton in the Libby trial told us they would allow jurors to ask questions, I and my colleagues were all skeptical that this was a good idea. Having gone through that process, I think it's actually a terrific idea. The jurors' questions were actually kept them both engaged, but really helped counsel during the trial on both sides. And what becomes remarkable is you're sitting there with a colleague at the table saying, gee, I think that's a little confused now. Should we straighten it out? Somebody else says, no, I think they're fine with that. And maybe we don't want to focus on that issue. And I think they're fine. Let's make a short, simple, redirect examination. And then you ask your questions, and then the first note on the jury is the question you debated asking. And you obviously had made a mistake thinking that this was not important. And there were even times where the questions that you wanted asked, but you did not want to be the one to ask them, because there were tactical reasons why it wasn't in your interest to be the one asking it. And I noted at least once in the Libby trial, when I got to the bench, I realized I was happy that the juror had asked that question I was afraid to ask, and the defense seemed happy that the jurors were asking the question that they were afraid to ask. And we were both happy that the question got asked while we could sit at our seats, and if the question answer turned out the way we didn't want it to be, we could still feel comfortable that we hadn't highlighted how important that was. So I think it's something to look at. Let me just end with sort of turn to my last point. I think we study lots of things about jurors and we have experiments, but the overarching thing that's come across to me, sitting in courtrooms where judges control the courtroom, and you're sitting there with anonymous juries and long trials, and there's a lot of tension, either because it's a violent case or a high-profile case. I think the best way to ensure that the jury does a good job or a terrific job is not just a careful jury selection, but the way judges treat juries in the courtroom. And there's something to be said, and it's hard to quantify, but when a judge makes it clear that he or she respects the jury, that they're going to be there on time, and that the lawyers will be ready to start, that there won't be inordinate delays. When judges have lawyers come in at odd hours or before trial or after trial or the day off to deal with legal issues, when judges keep tight control of sidebars so jurors don't spend their time idling while lawyers argue, when judges give a schedule in advance of what days will be off so jurors can make good time of that, when judges involve the jurors by letting them take notes, by letting them ask questions, and letting them have reasonable control of their schedule and deliberate, I think you see that juries greatly admire judges, and when judges give them instructions that we all want them to hear and believe, jurors take it very seriously. Let me make a brief digression to something that may be a hopeless cause, but I feel obligated to talk about it. I think there's been a public perception at times that people casually take shots at juries, and when people get a result in a case they don't like, whether it's a counsel, whether it's somebody outside the case that's unhappy with it, we casually just dismiss that as some error of the jury, as if we from afar can decide, based upon limited facts, through the filter of the news media in a digest form, how we would have decided something where people took their oath of service and sat in a room and heard all the evidence for themselves and made a decision. But if people are casually libeled, the people most casually libeled are grand jurors. And you often hear it said that people can get anything they want from a grand jury, that a grand jury would indict a ham sandwich. Well, I will tell you that a grand jury does work pretty quick in a simple case. And if there's a case where somebody robbed a bank and you have the picture of the guy robbing a bank, it doesn't take very long to walk in with a picture of the bank robber before a grand jury and get them to indict. And it shouldn't take very long. But a real control on prosecutors is if you were to indict a ham sandwich, you will someday stand before a trial jury with the ham sandwich sitting at the defendant table, and you better be ready to put proof on. But what I think people lose sight of is that many grand juries are long-term grand juries. And they do not the simple cases, they do the complicated cases that you want people paying attention to. A number of times in New York, I sat, as a prosecutor, sat in a grand jury room with people who served for 18 months, who were later renewed for another 18 months, and would serve for a total of up to 3 years. And some jurors would serve 1 or 2 days per week. They put a substantial investment. And the grand jurors in these long-term cases, when they saw live witnesses, paid attention, they took notes, and they asked remarkably intelligent questions. And I remember the grand juries that investigated Al-Qaeda and other serious activity were very invested in what they did, very committed to what they did. And they asked good questions, and they asked good questions both for the government, sometimes things you forgot to ask and were embarrassed when the grand jury asked a better question than you did. That happened quite frequently, and often for the defense, to make sure that we weren't missing something. And I think we don't give credit to grand juries these days. And people show up with a grand jury notice, and they roll their eyes, and are thinking that it won't be very interesting, and they come away from a very different experience. And the best example I can give you is the Libby case. In the Libby case, the grand jury actually asked a question which formed the basis for one of the counts of the indictment. Scooter Libby was convicted of lying to the grand jury in response to a question from the grand juror, which shows you that it was an alert grand juror to ask an appropriate question, and that's something that gets lost. What I'd like to do is just end with a note about the public perception about jury service. If you think back in time to how hard fought it was that we had jurors who had the right to sit, how in the initial history in English times juries were abused, how important it was to our central role in both the Declaration of Independence, the Constitution, and the Bill of Rights that we have trial by juries. A number of cases over the years, what's important is what jurors believe about their service, and that's shaped often by the public. And if the public perception is that jurors can be easily slighted, if the public perception is that juries don't work, if the public perception is that they're not important, that hurts. From what I've seen over juries over the years, both juries that agree with me and disagree with me, is that remarkably attentive. And as frustrated as you may be when you lose a case, you recognize that the jurors do their best. When they step into that jury box and they raise their oath, they act differently than when they're outside the jury box. The person who watches TV and in 2 minutes decides so-and-so did it, they're guilty. when they walk into the jury box and take an oath, they expect proof. They expect the government to prove things beyond a reasonable doubt. And too often of late, it seems that after a jury verdict is returned, we have efforts either to try and look behind the verdict, people probing into jury deliberations, which I think is very, very dangerous, but also people commenting too casually in the media or for press conferences that the jury got it wrong, they were confused, they were overwhelmed, or they acted on the basis motives. I think the most important thing we can do in jury service, besides having judges continue the practice of respecting jurors and involving in the process, is to make sure we don't allow people to too casually attack the results found by a jury. And I think that if everyone who heard people besmirch juries very cavalierly after a verdict they didn't like, were to challenge that, we could send a message that jury service is as important as our framers made it to be. And with that, I'll wrap it up. Thanks.
For people who regularly come here, I need to warn you, this is one of their favorite moments. Because we get to watch the look on your face when I reach into this bag and you think, what the hell is this, okay? But as a token of our appreciation, this is the symbol of the law school. We call it the gargoyle. And it says, 2008 Thomas E. Fairchild Lecture, Patrick J. Fitzgerald. So thank you very much.
Thank you.
Mr. Fitzgerald has said he would not only welcome questions, but he's graciously agreed to encourage questions that go beyond the scope of his remarks. And I guess this last one.
You can ask whatever you'd like. I don't, I'll answer it, but I'll try. Yes?
Pat, do you think there are adequate safeguards in the Justice Department to guard against partisan criminal prosecution? I'm thinking of the governor of Alabama.
Well, I'll duck that specific question since that's a pending matter of which I know nothing, and I've seen enough over the years not to make a judgment based upon what I read in the papers. But I will tell you this, that in my experience in 2 U.S. Attorney's Office, Southern District of New York and the Northern District of Illinois, I can't imagine people in either of those two cultures getting away with a political prosecution. And the ethic in my office, I didn't know in the Southern District of New York what political affiliation people had, if any. I don't know at the Northern District of Illinois. You'd have to sort of know people pretty well to get to know that. And people are there to make cases. And if people thought there was a corruption case to be made, and they thought that someone was going light on it, they wouldn't stand for it. So all I can say is that over the last year and a half, there's been a lot of controversy around the Department of Justice. It's very, very important that we get past that. And it's both critically important that no one ever do anything in the name of the Department of Justice that's rooted in politics. And almost as important that people understand that and perceive that that won't happen. Because when you stand up in a courtroom, people have to understand that you can be wrong. And you may bring a case where your proof doesn't measure up, or you can bring a case where there's a mistake of law. But they can never understand that you're bringing a case for some partisan political reason. I've never seen something when I was in New York where I had that concern. I don't think any of the attorneys there would have stood for it. And the same thing in the Northern District of Illinois. If you're asking if there's anything in the Department of Justice that prevents it, I don't think there's a regulation. I always think when we get to ethics, people always want to have a regulation. We go and we send people to a CLE class that says, don't lie, cheat, and steal. And I don't mean to make light of it, but sometimes we think if you put people in front of a video, they understand that. It's culture. And I think the culture of the offices that I've been in and in other offices I've worked with have all had that value that you go straight ahead. And I think the safeguard is the institutional integrity of each U.S. Attorney's Office, which each one of us inherits from decades before us, and each one of us has to leave in at least as good a shape. Yes?
The Wisconsin Law Review is publishing an article about the moral obligation that we have to jurors, specifically about exclusionary rules, essentially saying that we should allow the jurors to hear items of hearsay or character evidence because of their autonomy, because of the respect I think that you talked about. We're asking them to swear an oath and we hear the evidence, but we limit so much. And I was wondering if you had any comments of whether you felt that those laws were too limited, or should we allow the jury to hear more?
And I should have qualified my whole remarks, speaking personally and not on behalf of the Department of Justice. I think we'd be crazy if we took out all the exclusionary rules and let everything in. If for no other reason, then where would we stop? And I think we'd end up punishing the jurors by trials that are long now would be interminable. So we have to have some rule of reason, and we have to cut things off at a certain point. And certainly if you want to exclude things, one reason for the exclusionary rule in particular is to punish the policeman who breaks the law. So if someone kicks your door down and gets evidence, and the only way to stop people from kicking your door down is to make sure that they know if they do so, it'll never end up in trial, then turning around and telling the jury, here's what we found behind his door after the law was broken, would undermine that. Having said that, though, I do think, and it's hard to put your finger on and explain why, Rule 403 decisions are made by judges. When judges decide what does a jury get to hear, how much is it unfairly prejudicial versus probative, I do think that there can be a lot more latitude sometimes to let jurors know things. I think we often have this bias that says, well, the judge and the lawyers can know certain facts and realize that it's relevant for some parts but unfair to hold it against someone. But we can't let the jurors know that. And there's an assumption that jurors will sort of use the evidence for improper purpose. And I don't know why we so lightly assume that sometimes, or why we assume we can't tell jurors, look, we're letting you know this for one reason, but you can't hold it against a person to do that. We trust jurors not to convict people because they don't take the witness stand. And jurors acquit all the time in cases where defendants don't take the witness stand and explain themselves. So if I had to advocate to let jurors see more, it would be items that are relevant and not gained illegally, but where there's a balancing between whether or not the information is probative versus prejudicial. I think sometimes lawyers and judges assume that jurors can't handle it when I think they can handle more. Okay. Yes?
The juries, as a fact, seem to be disappearing in both the criminal and civil sides of things. So what should our response be? Should we make efforts to have more jury trials to keep the tradition alive?
Well, I will speak less on the civil side since I haven't been a civil practitioner. We have people in my office who are civil practitioners, so I won't speak on that side. But on the criminal side, we have jury trials. The bench trials are very rare. The disappearance of the jury trials is really the disappearance of a trial, and that has more to do with people plea bargaining in state systems and the sentencing guidelines in the federal system. And I think that really has to do with the defendant's choice about whether they want to go to trial and take the risks that they may get a more severe sentence. And I wouldn't change that. The legal system, the criminal justice system, exists to vindicate the government's interests and to give a defendant a fair trial, not to keep jurors busy. But if we're going to do trials, I do think that, at least in the criminal arena, we have to cling very, very hard to making sure that jurors are not just participants, but they're active participants and given a full voice. Someone down the middle, I think.
I'm not sure my voice will carry.
Well, I think it does.
My journey in the law began more than 50 years ago, and at that point in time, both in the federal and the state courts, lawyers played a significant role in the voir dire. Comment, if you will, on the changes, and is that for the betterment of justice?
Well, I've never been in a situation where the lawyers played too much of a role in voir dire, so I can't do much of a comparison. I will tell you that I am more comfortable, maybe because that's the way I was brought up as a prosecutor, having the judges do the voir dire. And I'm uncomfortable, and maybe it's because I haven't seen it enough, that sometimes when the lawyers do the voir dire, they spend more time pre-arguing their case to the jury and actually figuring out whether they want that juror, and spend more time framing the case in a way that they think is helpful. So it's sort of like a pre-argument. And I think that judges can do a better job of asking questions designed to get at biases, and they're not trying to pre-argue the case, so I felt more comfortable that way. But I have not been in a system where the lawyers did substantial questioning. The most questioning I did, I think, was in the Libby trial before Judge Walton. But I'd much prefer have the judge ask the questions in most instances, perhaps with limited follow-up by counsel.
You mentioned in your talk that you thought it was a bad idea to probe probe into the jury deliberation process. Now, I'm not sure whether you were saying in individual cases and what happened, or in general, because it's an area that I think many of us who do practice law are very interested in, the jury deliberation process as a whole and probing into that. Can you expand on that a little?
Yes, and I was casual in how I said it. I definitely think we want to think about how the jury deliberation process works. And anyone who does studies where they do mock juries and see how things work, that's very valuable. I meant in a given case, we treat jurors, for lack of a better word, as a black box. We give them the law, we give them the facts, they go in a room, and they act like the conscience of the community, and they come back with a verdict. And I think we would be extremely reluctant to start probing into what happened in the jury room, short of real proof of sort of jury tampering or something like that. We ought to let people serve as jurors relatively anonymously, and they should feel like they can speak candidly, particularly lay people, and throw their views out there and have other people push back and come to a conclusion without later feeling like they're going to have to air how things went. And I think that it's a tactic that people use to try to find any excuse to try and get the nose under the tent to find out what happened there. So my remarks were confined to getting into the results of a particular case after the fact. I think we should just salute the jury, thank them for their service, and respect their verdict. Okay. One? Sure. Yes. That's it.
Given your lead role in the Libby case, I was just curious as to how it felt personally for you when President Bush changed his punishment and decided it was unreasonable.
I don't comment on that for the following reason. You know, the Constitution, which is what we live by, gives the president the power to pardon. And I'm a prosecutor, and I have to make a responsible decision as to whether to prosecute or not. And then the president makes decisions with pardoning. And so I respect the role of the president, and it's not, it's not about how I feel. That's important. It's, I have to do my job in a way I feel comfortable with, and the president has to do his job, and it's not for prosecutors to comment on pardons. I think in the events that happened afterward, a lot of comments were made by talking heads about the situation that Mr. Libby faced. I do think that Mr. Libby, from the commentators, was I think unfairly portrayed as receiving an inappropriate sentence. And what I've tried to explain to people is he received justice in accordance, at least as well as everyone else in the system. He was represented by able counsel from multiple able firms. He had a fair trial. He had a jury that was very, very attentive. And so that people shouldn't lose sight of that. But I won't comment on and I keep saying pardon, it should be commutation, which is an important difference, but I shouldn't comment on that. Maybe one last question? Yes?
For those of us that are practicing trial attorneys, off the top of your head, do you have one or two recommendations for reference materials that you maybe use regularly that you found to be really helpful?
Yeah, it's not been very helpful to you. I bounce everything off fellow assistants. No, but it's true. I think the one good thing about a U.S. Attorney's Office is people have no pride of admitting what they don't know, and you walk down the hall and weird things happen all the time, and you just walk down the hall and say, you'll never guess what just happened, and there's usually someone who says, oh, that happened to me 2 years ago, and here's what you do. So I do think if you're in trial practice, having good colleagues that you trust and that you're not afraid to let them know what you don't know and bounce things off them is very helpful. And the other thing I think I find helpful is when we have trials is to bring people in for mock jury arguments, particularly people outside the case, particularly secretaries or paralegals who don't know the case. And I think that people generally in the legal profession edit every word in a brief, and you sit around and you look at one sentence in a page of 80-page brief, and people say, well, maybe we should phrase it this way, maybe we should phrase it that way. We draft indictments, how many people review it and change every comma, and we should phrase it this way. And then often you see practitioners who are like grabbing together their opening statement and going up in front of a jury, which has a lot more impact than any given brief. So I think lawyers in general don't move their oral advocacy in front of a juror, and they should particularly do it in front of lay people who are unfamiliar with the case, because we get so close to the facts. The names mean something to us. We start using shorthand for certain things that we shouldn't use shorthand for. So if I would recommend one thing, which I do recommend in my own office, is make sure you take the time to do your opening statement get it ready long enough in advance of the trial that at least you can do a dry run. And if people want to tell you, God, that's terrible, take the whole engine apart and reconstruct it, it'd be time to do that. Well, thank you very much.
Thank you again, and as our regular attendees know, we'll have a reception outside the door, and I hope you can join us. Thank you.